The start of a new year brings a fresh slate of legislative agendas from Washington, D.C. to the 50 states. In 2025, some may include efforts to chip away at abortion rights, even in states that just passed ballot measures securing them. Voters considered 10 abortion rights constitutional amendments last year, the most on record for a single year. They approved 7 of them.
Historic ballot measures enshrining the right to an abortion passed in 7 states: Arizona, Colorado, Nevada, Montana, Maryland, New York, and Missouri, where voters backed a measure.
Now, back here in the state of Missouri, voters overwhelmingly passed Amendment 3, striking down the state's near-total abortion ban.
We have shown that when Missourians fight together, we win together!
Arizonans said in this election that they have had enough of these out-of-touch politicians trying to force their beliefs on us and make medical decisions for us.
Taking a look officially now, New York State Proposition 1, verified by Associated Press, that has passed with a 71% majority, 2.1 million.
Amendment 79 establishes the right to abortion in Colorado state constitution. Right now, it is legal by state law. The amendment also allows the state to use taxpayer funding to pay for abortions.
So doing the constitutional protection now has become this much more important, given the administration that we're heading into.
President Donald Trump's position on abortion has been hard to pin down. He's avoided getting into specifics, especially during his third bid for the White House. And when he did seem to take a stand, he'd walk it back. Last March, during the campaign, he told WABC conservative talk radio host Sid Rosenberg he'd support a national 15-week abortion ban.
The number of weeks now, people are agreeing on 15. And I'm thinking in terms of that, and it'll come out to something that's very reasonable. But people are really, even hardliners are agreeing, seems to be 15 weeks.
A month later, he posted a video about abortion on his Truth Social platform. There was no mention of an abortion ban. Trump said abortion policy should be left to the states.
At the end of the day, it's all about will of the people. That's where we are right now, and that's what we want, the will of the people.
There is little support for a national ban. A poll from Associated Press NORC, Center for Public Affairs Research, found at least 7 in 10 people oppose a nationwide ban on abortion or a ban on abortion at 6 weeks. 60% are against a 15-week ban, which is what Republican South Carolina Senator Lindsey Graham proposed just months after the Supreme Court's decision on Dobbs that overturned Roe v. Wade. The poll also found support for legal abortion has increased since Dobbs. Trump ended his Truth Social video by reminding his supporters the first order of business was to win.
You must follow your heart of this issue, but remember, you must also win elections to restore our culture and, in fact, to save our country, which is currently, and very sadly, a nation in decline.
But there are plenty of things that President Donald Trump can do that could be as consequential and far-reaching as a national abortion ban. And there's a lot that Republicans can do to limit their state's voter-approved abortion rights amendments. So, what's next for abortion? From West Virginia Public Broadcasting and PRX, this is Us and Them, the show that tells the stories about the things that divide us. I'm Trey Kay. 2024 not only saw a record number of abortion-related ballot initiatives, it was also the first election since Dobbs where abortion rights amendments failed. They did not pass in South Dakota, Florida, and Nebraska. In South Dakota, and especially Florida, the groups behind the proposed amendments saw anti-abortion state officials go to extraordinary efforts to keep the question from going before voters. Take South Dakota, which bans abortion except when necessary to save the life of the mother. Rick Whalen, chairman of Dakotans for Health, led the campaign to pass Amendment G. It followed the legal framework of Roe. There would be no restrictions on abortions in the first trimester, but increasing limitations after that, including a ban in the third trimester with few exceptions. Whalen says abortion opponents fought the proposal from the get-go.
They had this mob of protesters out there, screaming at our circulators, screaming at the voters that wanted to sign our petition. They stalked us and tried to intimidate us, and we prevailed.
Dakotans for Health got the signatures it needed to put Amendment G on the ballot, and the Secretary of State certified them. But an anti-abortion group sued, claiming Dakotans for Health violated election laws during its signature collection. Then Republican lawmakers tried to reverse Amendment G's certification.
They rushed through a bill in the legislature on a straight party line vote that would give people who signed the petition an opportunity to withdraw their signature after the petition had been qualified. As soon as that bill was signed by the governor, the Right to Life groups started trolling for people to withdraw their signature with no success. But they did not want to give the people a chance to weigh in.
In a surprising move, Dakotans for Health did not get the backing of two major abortion rights organizations, the ACLU and Planned Parenthood. They had problems with the amendment's language and the way it was drafted. Even though Amendment G would have given South Dakotans greater abortion access compared to the current near-total ban, it did not allow abortion up to fetal viability. That's when the fetus can live outside the uterus. It's generally around 24 weeks of pregnancy. OBGYNs also use the term fetal viability to talk about whether a pregnancy is expected to continue developing normally. Fetal viability was the standard other abortion rights amendments were seeking. Planned Parenthood called Amendment G inadequate.
We got attacked from the religious right for putting a measure on the ballot that they tagged as too extreme. And we got attacked from the left for not going far enough. We had embraced the trimester tenets of Roe v. Wade, thinking that that was a good middle ground in South Dakota. And so we were kind of stuck between a rock and a hard place, wanting to work with them, wanting their help, but at the end of the day, they just chose to not get involved with our efforts, which is unfortunate.
Amendment G lost big by an 8-point margin. Rick Whalen with Dakotans for Health said it failed because of a lack of money. He says he won't try again, but he expects someone will. Right now, Planned Parenthood is not committing to anything. In a statement to Us and Them, its North Central States chapter said, quote, "We are continually considering what steps we can take to protect and restore access to abortion care, including a potential constitutional amendment. Constitutional amendments are serious and expensive undertakings that we would only initiate after due diligence." ACLU South Dakota did not respond to a request for comment. Money was definitely not an issue for abortion rights advocates in Florida. In fact, the campaign for Amendment 4 was the most expensive abortion ballot measure in the country. That's because the stakes in Florida were high. The amendment would have restored greater abortion access in a state that had become a haven for women seeking abortions in the South. It would have provided a constitutional right to abortion up to fetal viability or to protect the patient's health. The backers of Amendment 4 significantly outspent their opponents. But the No on 4 campaign had the support of Republican Governor Ron DeSantis. He used his platform and state resources to undermine the amendment.
In the months leading up to the election is when Governor DeSantis really went full throttle Amendment 4.
That's Romy Ellenbogen. She reports on Florida state government for the Tampa Bay Times and the Miami Herald.
If you were to scroll on social media, if you were to watch TV, you would see these state-sponsored PSAs that really were put there to counter pro-Amendment 4 language.
In addition, Florida's Agency for Healthcare Administration launched a website attacking the ballot measure. The state's health department told TV stations to stop airing a Yes on 4 ad, saying it was spreading disinformation about Florida's abortion laws. The FCC called this dangerous and a likely violation of the First Amendment. And as in South Dakota, Florida election officials questioned the validity of petition signatures that had already been approved.
The Department of State had certified Amendment 4 to appear on the ballot early in 2024. And then months later, turns out they're conducting this big review of pulling all of these petitions. Election supervisors that we spoke to said it was unprecedented for the state to review petitions that they had already deemed as valid compared to, in a fraud review, looking at rejected petitions, which is what the state would have normally done.
It's not clear how much taxpayer money was used in DeSantis' campaign against Amendment 4, or how effective it was. A majority of voters, 57%, supported it, but the amendment fell short of the 60% supermajority needed to pass.
Will they try again? It's tough. I mean, the thing is, if they try again, it's going to be really difficult because even getting on the ballot is extraordinarily difficult. We have a really high bar of petitions you need to collect. It is an expensive state to do petition collection in, and that process is probably going to become even harder because DeSantis' election security office has expressed interest in kind of rewriting that process or making changes.
After the election, the head of Planned Parenthood Action Network, the organization's advocacy arm, said the fight was not over. The opportunities for abortion rights amendments are narrowing. Of the 16 states that allow citizens to initiate them, only 5, Arkansas, Illinois, North Dakota, Oklahoma, and Oregon, have not weighed in on a proposed amendment to protect abortion rights. North Dakota is an interesting case. Last year, a trial court ruled North Dakota's 2023 ban on abortion, except in cases of death or serious health risk, was unconstitutional. Technically, abortion is legal up to fetal viability while that case continues. But there are no clinics in North Dakota. They closed after the ban went into effect. Of the remaining 4 states, Arkansas and Oklahoma have near total abortion bans, while Illinois and Oregon have many laws that are protective of abortion rights. Illinois Representative Margaret Croak is a Democrat representing District 12 in Chicago. She won re-election to a 3rd term in November. She's made reproductive rights, maternal health, and children her special focus. Prior to joining the Illinois House of Representatives, Croak worked in the administration of Democratic Governor J.B. Pritzker, who signed the Reproductive Health Act in 2019, 2 years before Dobbs. It established a right to reproductive health care, including abortion.
We also have made sure that birth control can be given to a patient over the counter. We've made it so that insurance can't do any cost sharing with that medication. We've increased telemedicine when it comes to women's reproductive health care. And then personally, I've done a lot around IVF. So we're doing a lot around reproductive health care for sure in the state of Illinois.
Illinois also has what's called a shield law, protecting its clinics and telehealth medication abortion providers from criminal prosecution for treating women from states with bans.
There was fear that some overzealous AGs in other states would request information from the state of Illinois that then would lead to criminal charges for them traveling out of state. We also have a shield law that protects the providers and their licensure from any consequences. So if you are licensed in the state of Illinois and you perform an abortion on a woman who is in Missouri, we have shield laws for our providers.
Croak spoke to me before the election when Missourians overturned the state's near total ban. But nearly 3 months later, abortions are still not available in that state. Illinois is one of 17 states with shield laws that cover reproductive health care and gender-affirming care. That's according to the Center on Reproductive Health, Law, and Policy at UCLA. Croak says lawmakers quickly saw the need for shield laws. After Dobbs, 4 states bordering Illinois adopted near-total bans. In 2023, it saw more out-of-state abortion patients than any other so-called safe haven state. 41% of all abortions were for out-of-state patients, nearly double the percentage of 2020. Those numbers are one way of measuring Dobbs' impact on Illinois. Representative Croak offered another example. It happened in October when Greyhound was about to lose its lease at a bus terminal in Chicago.
And when that lease was about to be up and it was not going to be renewed, the first people who reached out to me were Planned Parenthood and other pro-choice groups because of the amount of patients that take the Greyhound bus to go seek reproductive health care. If that is not an indicator of how many people we are serving, then I don't know what is.
The Democratic Party has a solid hold in Illinois. It's held the governorship, the House, and the Senate since 2003, save for a brief 4-year spell with a Republican governor. While lawmakers in other blue states like Maryland and New York put abortion rights amendments on the 2024 ballot, Illinois' legislature chose not to do so. Croak says she's confident the state's laws will hold. She also says her colleagues want more time to consider other rights they may want to protect.
I think actually the biggest concern is how inclusive do we want this amendment to be? Because when we talk about the Dobbs decision, there was also a concern about how that could impact same-sex marriage, how that could impact gender-affirming care. Some of these other things that kind of fell in the Roe v. Wade decision, that we had this assumption to the right of privacy. And in Illinois, do we want to make sure at the same time that we are going to put a constitutional amendment about choice, do we want to include any of those other issues in the same breath? And if we're going to do something choice plus, we need to make sure that that messaging is just incredibly well done. And that takes time. It takes education. So I think that that is the conversation we're having right now.
Illinois Representative Margaret Croak is aware that President Trump could put federal restrictions on abortion, but she doesn't think that should stop state-level efforts to support reproductive rights.
I understand that there may be some desire to switch to a national fight, but what we've seen in Illinois and what's been successful for us is to actually always stay local, to always stay to those local specific races, not even congressional races, really focus on the state legislature and the executive branch. And if other states and advocacy organizations want to be successful, they should consider doing the same thing.
For those states with new abortion protections, it is now up to the state's courts to interpret them and determine how they'll be applied. Abortion opponents see this as an opportunity to whittle down the broad abortion rights now written into their state's constitution. Ohio offers a preview of what's to come. The state went for Trump in 2016, 2020, and 2024. Its governor, Mike DeWine, is a pro-life Republican. Ohio's House and Senate have Republican supermajorities. Despite the GOP's grip on the state, Ohioans voted in 2023 to add the right to make one's own reproductive decisions, including abortion, to the state's constitution.
Ohio became the first red state, really, to adopt an affirmative protection for abortion rights in the state constitution.
Jessie Hill is a law professor at Case Western Reserve University in Cleveland. She is also a volunteer attorney with the ACLU of Ohio and helped write the amendment known as Issue 1.
Ohioans may think that, okay, the fight is over. My state chose to make it a constitutional right. Is the fight over?
The fight is definitely not over, and I think it's something that is not as well known to members of the public who maybe aren't as kind of locked into these questions or as aware of what the landscape of abortion regulation looks like in Ohio.
Mike Ganadakis doesn't think the fight is over either. He's the president of Ohio Right to Life, the leading anti-abortion group in the state. It works closely with the Republican state lawmakers on abortion regulations. He says the passage of Issue 1 was a setback for his group.
The defeat was real, and we're not sugarcoating it. We lost last year in 2023. The fact of the matter is we can save lives regardless of what the federal Constitution says or the United States Supreme Court. Alternatively, what the Ohio Constitution says presently. Now, Does it make it more of a challenge? We have to take the old playbook and throw it out the window? Certainly. The things we do today in 2024 leading into 2025 are not going to be the things we did. When I say things, I mean tactics and strategies that we did in the 70s, 80s, 90s, 2000s. Again, I've been here 16 years. So we have to change our tactics and strategies because we're not introducing bans in Ohio anymore, whether it be 6 weeks heartbeat bill, 15 weeks or what have you.
You talked about there being an old playbook and I guess now a new playbook. So can you tell me more about that? What is the difference between the old way and the new way?
Sure. So the old playbook used to be, in my time and before my time, we would come up with 5 to 7 to 8 pieces of policy proposals for the legislature or the governor's office to pursue, whether that be limiting or restricting abortions in Ohio or other mechanisms. And we would introduce those bills and pass them, and we would call it a day. Fast forward to 2024, after Dobbs, after issue 1 here in Ohio, if we introduce a bill to ban abortion today in the Ohio legislature, everyone can high five and say that's great, but it's never going to save one baby's life because if we get it passed through the legislature, which we could, signed by the governor, it'll be enjoined by a court here in Columbus or Cincinnati immediately. It will never go into effect because they'll say issue 1 prohibits a ban on abortion. So instead of doing that and wasting time and resources, we're looking at ways to enhance adoption. We're looking at ways to get better grants via the legislature to our pregnancy centers, more opportunities for women, whether they need access to housing, childcare, tax credits for them. We're looking at the more practical, common sense approach because our polling demonstrates, Trey, that approximately 45% of women said in our polling that they had an abortion because they did not believe they had another choice.
Ganadakis says Ohio Right to Life is concentrating on the nuts and bolts of helping women with unintended pregnancies. But the organization remains laser-focused on abortion politics, especially the legal challenges stemming from the passage of Issue 1. Ohio has a law that bans abortion at around 6 weeks of pregnancy. It's been suspended since the ACLU challenged the law in 2022. After Issue 1 passed, ACLU volunteer attorney Jesse Hill went back to the trial judge and asked him to permanently strike down the ban. Last fall, he did. Hamilton County Common Pleas Court Judge Christian Jenkins, a Democrat, said his ruling upheld voters' wishes. Ohio's Attorney General agreed the 6-week ban was unconstitutional, but he still appealed the judge's decision. Hill says the AG claims other aspects of the law do not violate the Abortion Rights Amendment and should still be enforced.
For example, the requirement to test for the heartbeat is something that he felt should stay on the books. In other words, his view was that the amendment was very narrow and the only thing it prevented was actually banning abortion, and not these other restrictions, which clearly flies in the face of what the language was.
That language that Hill is referring to prohibits any state laws that, quote, burden, penalize, prohibit, interfere with, or discriminate against abortion care and abortion providers. Hill says this applies to rules that she argues are not medically necessary, like a 24-hour waiting period, a ban on telehealth visits, and certain informed consent requirements. They're currently suspended while the ACLU's legal challenge proceeds.
The language is written very broadly. It lays out a very clear legal test for courts to apply. The trial courts who have addressed it have found it very understandable and very protective.
Hill and Ohio Right to Life's Mike Ganadakis expect these cases to reach the Ohio Supreme Court.
We have words like reproductive health care in our Constitution now. There's no legal definition for that. What does that mean? What does that mean? I mean, I know what layman terms mean to me and you, but layman terms versus court of law and what the law is or the Constitution is two completely different standards. So we need the Ohio Supreme Court to interpret what these words mean in Issue 1.
There's another reason Ganadakis and other abortion opponents are keen to see these cases get to the state's highest court. Ohio is one of 7 states that hold partisan elections for state Supreme Court justices. 3 seats were up for election in November. All 3 went to Republicans, who now have a 6-1 majority on the state's high court.
We just elected 3 pro-life Ohio Supreme Court justices in the current makeup of the court, which is 7 members. 6 of them are endorsed by Ohio Right to Life.
You mentioned a pro-life pro-life majority on the court. I mean, aren't they supposed to address the law, not their conscience and belief? And can Ohioans expect impartial rulings?
Absolutely. So I can't guess what they're going to do, but what I do believe they're going to do is, here's what I told the voters of Ohio this last election when they were considering who to vote for. Do you want a liberal pro-choice majority on the court writing the first decision on issue 1, or do you want a conservative pro-life court writing the first decision on issue 1? And the voters of Ohio overwhelmingly chose the conservative court. I believe whether you're pro-life or pro-choice, I believe a conservative jurist on the Ohio Supreme Court is going to call the law and write an appropriate opinion that is based on fact. Will it be a conservative opinion? I hope so. Will it construe these words in a conservative light? I hope so. But just because a local judge in Cincinnati writes an opinion is not authoritative as being the final word. It's a moment in time. And I can assure you, Trey, with 100% degree of certainty, that the final decision from the Ohio Supreme Court as currently constituted will not look like Judge Jenkins' initial opinion.
What do you think Ohioans voted for?
I think Ohioans wanted to make sure abortion was legal. For cases of rape and incest, I believe Ohioans voted to make sure that it was there for emergency circumstances, situations. So the voters of Ohio are not now all of a sudden this obsessed abortion-minded constituency. What I think the voters wanted to make sure was that it was not illegal. They wanted to make sure that it was there, but rare.
The ACLU says the passage of Issue 1 shows that, quote, Ohioans have spoken loudly and clearly in favor of protecting the right to make decisions about their own bodies without government interference. In a statement released after the amendment passed, the group said the Ohio Supreme Court, quote, must honor the Ohio Constitution's clear protections for abortion rights. ACLU volunteer attorney and law professor Jesse Hill.
I would like to think that whatever party identification is next to a judge's name, that they will read the law and apply the law as it's written, that I would like to think that they're going to do their jobs. It certainly is a cause for concern as an attorney and as an attorney who may be litigating in front of that court. But, like I said, in theory and according to what conservative justices say, they believe that the text of the Constitution is worthy of respect and it's what they have to follow. And I think if they do that, we should still win all of our cases.
What's happening in Ohio is also happening in Missouri, another conservative state that saw a strict abortion ban overturned by voters. Republican lawmakers who hold supermajorities in Missouri's House and Senate are already proposing bills to weaken or overturn Amendment 3, which legalized abortion and won by a 4-point margin. State bans and restrictions have not made a dent in the number of abortions in the U.S. In fact, they're more common now than they were before Roe ended. That's due in part to the growing popularity of medication abortions. And that's put abortion pills at the center of the battle over abortion access. Abortion opponents want the Trump administration to effectively ban medication abortions by reviving a law from 1873.
I mean, it's a federal law. It's on the books. It would stop this trafficking in a chemical abortion drug that risks women's lives in a context in which there's no physician involved to protect her life. That's a real problem.
More on that effort and other federal anti-abortion options after a break. You're listening to Us and Them from West Virginia Public Broadcasting and PRX. This program is supported in part by the CRC Foundation.
Music lifts us up and brings us together, even when we can't get together in person. Mountain Stage brings you live performances on the air, online, and in our podcast. They remind you how it feels to be in a live audience listening to live music. This is Larry Gross, host of Mountain Stage. Find a link to our stations and our podcast online at mountainstage.org.
Trey, and you're listening to Us and Them from West Virginia Public Broadcasting and PRX. When the United States Supreme Court overturned the federal right to abortion, West Virginia and 13 other states passed bans with very limited exceptions. Even so, there were more than 1 million abortions in 2023, the highest number in more than a decade. More than 60% of them were medication abortions, a procedure that uses 2 prescription drugs. Medication abortion's popularity is one of the reasons abortion opponents are focused on limiting access to these pills. They argue the drugs can be dangerous, but regulators, doctors, and researchers say the pills are safe. Julie F. Kay, who is not related to me, is the co-founder and executive director of the Abortion Coalition for Telemedicine, or ACT. She started her legal career with the Center for Reproductive Rights. Kay says the safety of the drugs mifepristone and misoprostol have stood the test of time.
Both have been used globally for decades and have an extremely high safety rate, very low rates of complication.
Medication abortions have grown more popular since the pandemic, when the Food and Drug Administration ended rules requiring that specially certified doctors dispense the pills in person. Kay says the goal of the Abortion Coalition for Telemedicine is to help more doctors set up telehealth abortion practices.
Getting a practice set up is difficult. It takes technical assistance. How do you set up a payment platform? How do you make sure electronic medical records are secure and private? What kind of insurance, malpractice insurance do you need? And what kind of legal support do you need? So those are all the kind of nuts and bolts pieces that ACT offers to providers. And then we also have a patient supporting piece that makes sure that patients are getting the information and support they need.
Hey Jane was one of the first virtual abortion clinics. It launched in 2021 and has served more than 70,000 patients in 20 states and the District of Columbia. Hey Jane limits its operations to states that allow abortion pills to be delivered by mail. Alyssa Wagner is a doctor of nursing practice and the medical director of Hey Jane.
What we do that is becoming more and more common practice and is a really big benefit to our patients is what's called asynchronous care.
Asynchronous telehealth care is the official term for communications between a patient and a provider through texts or messaging platforms. It's often used for patient intake and follow-up care.
And what this means is the patient would fill out a really detailed health history form with us that is reviewed by our clinical team, where we ask questions if we need them, and we determine, is this patient a good fit for telemedicine abortion care? So a reason why somebody may not be a good fit would be, say, they have a history of a bleeding or clotting disorder where they would be better served in person. We review that with them, and if they are a good or a safe candidate for care with us, then we ship the medications to their home where they can keep in touch with us either via phone call, video, or chat, which a lot of our patients prefer chat. About 95% of our patients prefer to chat with us about their abortion.
The FDA recommends medication abortion up to 10 weeks of pregnancy. Many abortion providers perform an ultrasound to determine where a woman is in her pregnancy before prescribing pills. Some states require them, but Wagner says they're not necessary.
When you're pregnant and say it's a pregnancy you want and that you're planning to continue, and you call to schedule an appointment with an OBGYN, that's all 100% based on your last menstrual period. Everyone is not getting an ultrasound at their first visit with an OBGYN to confirm pregnancy. That is not the standard. The standard is dating based off of a last menstrual period. Now, there's reasons why you can't rely on a last menstrual period. And in those situations, we do order ultrasounds. But for the most part, a majority of the time, dating with a last menstrual period is the standard for dating an early pregnancy.
Medical abortions can be incomplete and require a D&C or a D&E. How does Hey Jane handle those situations?
Yeah, so many of the post-abortion complications we can manage via telemedicine. In the exceptionally rare, and I do all of our safety data, so I can really attest to this, in the exceptionally rare instance that a patient does need in-person care, we work with the patient based on their location and based on relationships that we have in the reproductive health space to get them a warm referral for in-person care.
While Hey Jane only offers its online services to states where such abortions are legal, the Abortion Telehealth Coalition's Trey Kay helps doctors in 8 abortion-friendly states set up telehealth practices to treat women anywhere in the country, even in states where abortion is essentially banned. What's important about these 8 states is that they have shield laws that explicitly protect their telehealth abortion providers from any criminal repercussions for sending abortion pills to patients in states with bans. Illinois is among the 8, so are California and New York. Kay helped draft its law.
So if there's a patient in Arkansas who's looking for access to a medication abortion and either can't travel or doesn't want to, she can go online to one of the telemedicine providers in a shield state who serves all 50 states and does the screening. The doctor sends the medications to Arkansas. She gets her medications. And let's say her angry ex-husband or something is like, I don't approve of this, I'm going after the doctor, and tries to get a criminal warrant against the doctor in New York. The state of New York, because of their shield law, is not going to send that provider down to Arkansas on a criminal charge.
Kay's example was hypothetical, but in the weeks since we spoke, Texas Attorney General Ken Paxton sued a New York doctor, saying she violated Texas law by prescribing abortion pills to a patient there via telemedicine. The doctor, Maggie Carpenter, is a co-founder of ACT.
Have you had a chance to speak with Dr. Maggie Carpenter, and have you heard her reaction?
I mean, I've worked closely with Maggie for a while now. I know her well. She's been incredibly dedicated to her patients and practice, and she really sees provision of abortion care as a human rights issue.
The lawsuit is the first test of an abortion shield law. Texas will need the help of New York to get Dr. Carpenter to participate in the lawsuit, and New York will not cooperate, citing its shield law.
I mean, it seems they might violate the Constitution. The full faith and credit clause requires states to honor the laws, judgments, and records of other states. So tell me why you think they'll withstand a constitutional challenge.
Well, the shield laws don't violate the Constitution. This has been researched quite thoroughly by academics, activists, government attorneys. I was quite involved with the legal research for the New York law, and I know that it was something that was looked at to comply with the Constitution. We've seen this happen before in the United States around marriage equality. You could be married in Massachusetts, but you wouldn't want to travel to a state like Texas that criminalized sodomy. So we're looking at kind of a similar situation right now. The clinicians that we work with that provide telemedicine abortion nationwide, they don't travel into states that are sort of vehemently anti-abortion. They don't go to Mardi Gras or South by Southwest. They don't visit family in those other states. They have really made a commitment in their lifestyle to stay where they will be protected and able to practice. I don't, use the word hero lightly, but I think that they have really stepped up in recognizing that they have a duty as a healthcare practitioner to provide safe care and to help people access their human rights to decide whether, when, and with whom to have a child or not.
This is surprising to me, and it's given me a different perspective. This seems like a result of returning it to the states that I hadn't really considered.
Well, in some ways, it's a positive result, because these are states that have said, you know what, we see what's going on in other states where, despite a Democratic majority in favor of abortion rights, say in Florida, nonetheless, the state is still banning reproductive health care and banning access to abortion. So these are states that are really stepping up to defend rights.
As abortion activists like Trey Kay work to expand access to telehealth medication abortion, opponents offer several ways for President Trump to stop it. They're written down in Mandate for Leadership, the Conservative Promise, a document otherwise known as Project 2025. The plan, from the Heritage Foundation, was created by conservative analysts and former and current Trump administration officials. Trump disavowed it during the campaign, but his transition team used it to help staff his administration. Among other things, it suggests President Trump restore a rule requiring doctors to distribute abortion pills in person. The FDA suspended the requirement during the COVID-19 pandemic and made the change permanent in 2023.
Now you can order from some company in Zimbabwe and receive it in your home, take it in your home, and possibly lose your life because it has a significant severe complication.
That's Jim Bopp Jr., longtime general counsel to National Right to Life. He's one of the top legal minds in the conservative movement. The New York Times has called him the most prolific anti-abortion litigator of his generation and a bulldog litigator. So would you want the Trump administration to reinstate the in-clinic dispensing of abortion medication?
Yeah, that requires a doctor to supervise the taking of a deadly drug.
The people that I've spoken to for this program, they say that mifepristone isn't deadly, and yet you're calling it a deadly drug.
There are deadly side effects to this drug that women have died from.
I guess I'd like to see the statistics on that.
Well, Google it.
The FDA says on its website that over the course of 22 years since mifepristone was first approved, 32 deaths have been reported in connection with its use. 32 deaths out of nearly 6 million patients. The agency said those deaths could not be linked conclusively to mifepristone because of other factors, like sepsis, underlying health problems, and drug addiction. One case involved a person who died by suicide. Another was a suspected murder victim. In a broader look at the safety of both drugs, the New York Times reviewed more than 100 studies of the mifepristone and misoprostol regimen. They covered 30 years of global data on more than 124,000 abortions in the first trimester. The vast majority reported no complications in 99% of patients. All concluded the pills were safe to use. Still, abortion opponents say the pills, especially mifepristone, are potentially dangerous, and they're looking for ways to get them off the market. This includes a recent challenge to the FDA's approval and regulation of mifepristone that made it all the way to the Supreme Court. Last year, the High Court's justices unanimously rejected that lawsuit, saying the anti-abortion doctors and activists who brought it did not have standing. However, the court left the door open to future challenges. The in-person requirement would end virtual medication abortions. Another plan mentioned in Project 2025 would get rid of them, and perhaps all abortions entirely. It calls for the Department of Justice to enforce a 19th century anti-vice law, the Comstock Act of 1873. The law prohibits the mailing of obscene material, including anything designed to produce an abortion.
They basically state that use of the U.S. mails is prohibited for any lewd and lascivious material, so this would include things like pornography or sex toys.
Kiki Friedman is the CEO and co-founder of Hey Jane.
It previously included use of the U.S. mails for birth control and contraception, and then any instrument that can be used to cause an abortion.
Congress has amended the Comstock Act multiple times. It repealed the ban on mailing birth control in the 1970s. However, there is still language that prohibits mailing, and I'm quoting here from the statute, every article, instrument, substance, drug, medicine, or thing used for producing an abortion. Anti-abortion opponents believe Comstock could stop providers from mailing pills to patients. But if interpreted more broadly, it could also block manufacturers from shipping pills to providers in the first place. And as Carrie N. Baker, a professor of American Studies at Smith College, told Vox Media, it could also halt the shipment of surgical abortion supplies.
About 2/3 of abortion are done with pills now, but about 1/3 are done with instruments. And mailing those instruments could be a violation of Comstock law if the Trump administration interprets Comstock as prohibiting the mailing of anything that could accomplish an abortion. And that would shut down abortion nationwide in all states because every doctor orders things from out of state.
In 2023, a group of congressional Republicans wrote to the Biden administration demanding the Justice Department enforce Comstock and stop, quote, the reckless distribution of abortion drugs by mail. Hey Jane's Kiki Friedman says that's not how the DOJ or the courts have interpreted the articles of the Comstock Act.
They have been brought before the courts many times, and in every single case, the courts ruled that the Comstock law is only applicable to unlawful abortions, that lawful abortions are not affected by this rule. That said, we know it's become an area of increasing interest among anti-choice folks, and so they will likely try to misapply that rule to restrict access in the coming years.
I asked Right to Life attorney Jim Bopp Jr. what he thinks of President Trump using the Comstock strategy.
I think it's legally available, and he should do that. I mean, it's a federal law. It's on the books. It would stop this trafficking in, a chemical abortion drug that risks women's lives in a context in which there's no physician involved to protect her life. That's a real problem.
Last summer, during the presidential campaign, Donald Trump told CBS News' Caitlin Huey Brown he would not enforce the Comstock Act. That comment greatly angered conservatives and anti-abortion activists.
As president, would you enforce the Comstock Act, which could prohibit the sale of or the distribution of medication abortion by mail?
No, we will be discussing specifics of it, but generally speaking, no, I wouldn't.
You would not enforce the Comstock Act?
I would not do that.
Should medication abortion be widely available?
Well, it's going to be available, and it is now. And as I know it, the Supreme Court has said, keep it going the way it is.
In other words, leave abortion policy to the states. Could Trump order his Department of Justice to enforce the Comstock Act without violating his campaign promises? I put this to Jim Bopp. If President Trump takes any national action to limit abortion, he would risk.
He said he's not going to do that. Why are you even asking me?
That's kind of the way I was going to ask the question. I mean, if he were to take action to limit abortion, he would risk going on his words that it should be left to the state. What action?
He has said repeatedly he's not going to do that.
Well, what actions do you think that he can take where he would not go back on his word?
Well, interstate transport is not governed by the states. Interstate transport is governed by federal law, and federal law already has a prohibition on interstate transport of abortion drugs. So this no new law, it's been around for quite a while. It's very specific. So his commitment not to try to limit abortion in the states by federal law is perfectly consistent with the federal government's authority to regulate interstate activities. And that's what he would be doing with the Comstock Act.
Jim Bopp Jr., the longtime legal strategist for National Right to Life, sees the Comstock Act as a way for President Trump to maintain a pro-life legacy while honoring his stated intention to leave abortion regulations to the states. The nation has the next 4 years to see how this will play out. As I was working on this story, I remembered a conversation I had decades ago with a friend about abortion. I mentioned it during a follow-up conversation with Julie F. Kay, the co-founder and CEO of Abortion Coalition for Telemedicine.
I remember one of the things he said to me, he goes, I think that the issue of abortion is going to be
it's going to be over. It's going to be moot because we are going to go to medication abortion, that it's going to be something that a person, a woman elects to do on her own. She's not going to go into an office to have this procedure done. And that's going to take this issue off the table.
It's interesting. I was working at the Center for Reproductive Rights in the late 1990s when medication abortion, the so-called French abortion pill, or RU46, first became available. I remember my father called and he said, well, now that the French abortion pill is here, what are you going to do? Where are you going to work? Because I think he was concerned either about job security or had a similar view that this kind of took care of everything. And that was really at the height of clinic violence and terrorism against providers. And that is why women like it. They are choosing medication more and more. We live in a world where telemedicine is very popular. And we're looking at a very small, politically powerful and marginalized section of elected officials and others who want to take away these rights for everybody.
I remember thinking when I had that conversation with my friend that abortion pills would quiet the politics of abortion. President Trump has said the same thing about the end of Roe versus Wade. But that doesn't seem to be where this is going. You've been listening to Us and Them. Our team for this show was me, Trey Kay, Amy Eddings, and Kate Smith. Special thanks to Karen Cross. Michael Lipton, Tristan Lozow, and Ahmed Solomon wrote and performed the Us and Them show music. Mark Lerner designed our logo. The marvelous people at PRX and West Virginia Public Broadcasting make Us and Them possible. So do grants from the Corporation for Public Broadcasting and the CRC Foundation. We'd love to hear your thoughts about this episode. Would you share them with us on our Facebook page or on X, formerly known as Twitter, at Us Them Podcast? Us and Them was originally developed with assistance from the mentorship program at AIR, the Association of Independents in Radio. We'll see you next time on Us and Them.
Support for this podcast comes from the Corporation for Public Broadcasting.